Recall the case People versus Benjamin Detla.
After lobby for the people.
And on behalf of Mr. Dallas, please should be appeared by Zoom. Mr. Dallas, can you please state your name for the record?
Yes, Benjamin J. Phillips, Your Honor. Your Honor, maybe we have a breakout room first.
I'm sorry?
Can I go to a breakout room with my attorney?
Well, I can't put you in a breakout room where she is in person and you're not.
Then I can come see you after.
So after we're done, she's indicating she'll come see you.
Right away, this hearing opens with confusion, tension, and a defendant who clearly feels overwhelmed before the real legal discussion even begins. Judge Simpson immediately has to slow things down and regain control of the courtroom rhythm because Benjamin is interrupting, asking to speak privately, and trying to navigate the process emotionally instead of procedurally. That matters. In courtroom settings, judges pay attention not only to what someone requests, but how they handle themselves while requesting it. What's interesting here is that the judge does not come out aggressive. He actually stays calm, patient, and measured despite the interruptions. That tone becomes important later because it shows the court is willing to work with the defendant as long as structure and legal procedure are respected. The defense is already hinting at competency concerns and mental health treatment, which immediately changes the entire energy of the case from punishment-focused to evaluation-focused. And viewers, pay attention to this early moment because these small interactions often foreshadow how the judge will handle discretion later. Is the defendant simply emotional and confused, or is the court seeing deeper competency issues that affect the entire prosecution moving forward? That question quietly starts right here.
Can I just talk to her real quick?
What?
Can I talk to you? Speak to her real quick?
You guys are in debt. You guys are very different.
Your Honor,
she's in the courtroom.
I know.
You're not.
Personal recognizance. Did you get my message about the personal recognizance bond, Stephanie?
I understand that you want to be released on bond, Mr. Detlis. Yes.
Yeah, the personal recognizance bond. That's all. That's all I wanted to say, Your Honor. I'm sorry. I apologize.
No, it's okay. It's okay. I get it. So, what are we doing?
Thank you, Your Honor. Last week, the court was kind enough to forward me information regarding my client's current evaluation as to competency. And based on the document tendered to me on that day, signed by Andrea Zendra, I believe, Mr. Detlef is not competent to stand trial, but they do believe he is likely to attain competency if provided the appropriate amount of treatment. Your Honor, we would stipulate to those findings.
People would also stipulate to the findings have no further evidence.
All right.
As the court signed any proposed order of continuing treatment.
Based upon a review of that report, the defendant at this time is incompetent to stand trial. I will set a competency review hearing May 22nd, 2025, 9 a.m.
Thank you, Your Honor.
Your Honor, and I believe the court has heard from my client where he is asking for a personal recognizance bond. I'm speaking to my client. He just wants to get out and start receiving some mental health treatment, and he is just asking the court's indulgence to allow him such treatment options.
Please, Your Honor.
Until something's in place, I'm not going to change the bond. This bond will continue. Once something's in place, I will be more than happy to look at it again.
Thank you, Your Honor.
Now, this is one of those moments where the court draws a very hard line between sympathy and legal responsibility. The defense is essentially telling Judge Simpson, look, this defendant wants treatment, wants help, and wants the opportunity to stabilize outside custody. But the judge's response is crystal clear. Wanting treatment is not enough by itself. Courts need structure. Courts need supervision plans. Courts need proof that safeguards exist before somebody gets released. That phrase, until something's in place, is doing a lot of work legally. Judge Simpson is signaling that he's not completely shutting the door on bond reconsideration, but he is absolutely refusing to take a leap of faith. And honestly, from the bench's perspective, that makes sense. Once a defendant is released, the court carries the risk if things spiral out of control. This is also where courtroom reality clashes with emotional reality. The defendant may genuinely want help. Defense counsel may genuinely believe treatment is the better path. But judges are balancing public safety, court compliance, and future appearances, not just intentions. Intentions alone do not secure release. Structure does, documentation does, accountability does. And notice how calm the judge remains while still denying the request. That controlled delivery sends a message to everybody watching in that courtroom. Procedure comes first.
I
Right.
look into treatment for me, if I buy some treatment options for me.
Okay, what, Mr. Deadlever, what you're gonna have to do is talk to your attorney about any requests that you're making. And they know the proper form to get it to me in. I'm not saying I won't look at it and won't release you, but there has to be something in place prior to my doing so.
Thank you, Your Honor.
Thank you. I'll make sure, Ms. Cannon, get those orders into me, please.
Yes, Your Honor.
Court does call the case of the people versus Marquise Hankey.
Alexander, on behalf of the people, Your Honor.
Good morning, y'all. Attorney Kevin Basant, P71061, on behalf of Mr. Marquise Hankey. Mr. Hankey, state your name for the record.
My name is Marquise Hankey. All right.
And Judge, we're asking for an adjournment. I just got substituted into this matter yesterday, Your Honor, and we're asking for an adjournment for discovery.
That's fine, appropriate.
During the matter, March 13th, 2025, 9 a.m. Yes, that's about.
Your Honor, I'm not sure, is the court in receipt of the bond violation report?
I am not.
I have not reviewed it either, Judge, but I'm certain what it would say, but.
Your Honor, I have a report from February 24th of 2025 that the defendant had absconded from his tether and had been unable to be located. And they stopped supervision. I also wanted to address his jail.
Oh, that.
When he got out.
Do we have that?
No, we do not.
This hearing suddenly shifts from procedural housekeeping into something much more serious once the tether violation and jail call allegations enter the conversation. Up to this point, defense counsel was asking for time, discovery, and standard pretrial considerations. But the second the prosecution starts describing absconding behavior, missing supervision, and indirect victim communication, the entire bond conversation changes. And listen carefully to how prosecutors build these arguments. They don't just say, "We're concerned." They stack behaviors one by one, cutting the tether, disappearing from supervision, using third parties to contact the victim, then allegedly continuing communication through different numbers. That creates a pattern argument. In bond hearings, patterns matter far more than isolated excuses. The prosecution is also strategically emphasizing manipulation here. They're framing the defendant not as confused, but as somebody actively trying to work around court restrictions. That distinction is massive because judges take no-contact violations extremely seriously, especially when the allegations involve intimidation, emotional pressure, or potential witness influence. What makes this hearing dramatic is that both sides are now telling completely different stories about the same conduct. One side sees fear and panic, the other sees calculated defiance. And Judge Simpson is about to decide which interpretation he believes more.
And you're aware of this?
I am, Judge.
And I also want to address his jail calls from before he was released.
Yes, go ahead.
In those calls, the defendant contacts a third party who then contacts the victim. The defendant says, "I need you to do me a favor." So you have that number right, and the person says, "Whose number?" He does, "Who is the victim?" He says, "I can't say the name, I can't tell you, but I need you to do me a solid." He said, "Okay, what?" "Tell them I'm thinking of you." And he says, the defense says, "Y'all been talking, right?" He says, "No, I've only been talking to Peter, who's the victim." He says, "Can't see that name on my phone, on the phone, because she's my case." And then in the next call, the defendant gets her added to the call. He calls the third party who then connects her to the call, and they're talking. And I also have concerns that he would be contacting her at a different number because I had a note from Detective Mosher that he had been contacting her as well as a different number. I'm just not sure exactly what that number is. And given the facts of this case, I'm extremely concerned.
And may I address all those issues, Your Honor?
Yes.
And so briefly, Judge, my client
Just
is
so that I know, currently right now, he was ordered on a tether and he's not on a tether right now.
absolutely not, Judge, and I'll address it. So Judge, if I may, so Mr. Hankey, he's 22 years old, Judge, has no criminal history whatsoever. This is his first ever contact with the law. Literally, Judge, 3 days ago, he admittingly cut his tether off. He got overwhelmingly scared. He didn't understand what he was actually charged with. He thought he was charged with a life offense. I told him, no, it's a felonious assault. He was under the impression that he was immediately going to prison today because he didn't understand the law. And so he freaked out, Judge, and he indeed, admittingly, he cut his tether off.
Defense counsel is making a very calculated emotional argument here, and honestly, it's one we see often in high-stakes pretrial hearings. The strategy is simple. Acknowledge the bad conduct immediately, then reframe the motivation behind it. Instead of portraying the defendant as dangerous or intentionally fleeing, the attorney is trying to portray him as immature, overwhelmed, frightened, and mentally flooded by panic. Notice how the lawyer repeatedly emphasizes age, fear, misunderstanding, and anxiety. He thought it was a life offense. He got scared. Fear got the best of him. Every sentence is designed to reduce perceived criminal intent, because legally, intent matters. Judges can sometimes forgive panic-driven mistakes more easily than calculated manipulation. But here's the problem for the defense. Tether violations are already difficult to explain away, and when you combine that with alleged victim contact, the argument becomes exponentially harder. Once a court believes someone ignored conditions knowingly, judicial patience evaporates fast. Still, the attorney does one smart thing here. He repeatedly reminds the court that the defendant returned voluntarily. That's not insignificant. Defense counsel is basically saying, if he truly intended to flee, he wouldn't be standing here right now. That becomes the core of the second chance argument moving forward.
I immediately spoke with my client. I told him not to run, not to go anywhere, to address the court and to be upfront about it. And so, Judge, he's here today. He had every opportunity to not be here today, every opportunity to run, and he didn't. He takes full ownership for cutting that tether off, Judge. If I had talked to him before he did it, I don't think it would have ever happened. But Judge, I don't think he did it intentionally to, flee from the court. I believe he did it, honestly, Judge. And if hear me out, Judge, I think this is a situation, Your Honor, where fear got the best of him, anxiety got the best of him. In terms of the jail calls, Your Honor, I would.
Do we have the tether back?
Your Honor, I'm not sure, but I did also want to address that the defendant does have a juvenile adjudication for a CSE fourth and a dismissed DV from 2022, in which the victim failed to appear as well.
Judge, community corrections have the tether back, and there's been communications with the tether agent and the office. And so, Judge, in terms of the jail calls, I was just made aware of those this morning. I would note that his the complainant in this case is his girlfriend. She's currently pregnant. I told my client to have absolutely no contact with her whatsoever per the bond conditions. And so, Judge, I make this argument, Your Honor, because honestly, I'm asking the court if they would give him a second chance. There was a $70,000 cash surety bond. That bond was posted. But for his actions 3 days ago, Judge, we wouldn't have the bond violation, at least with the tether. With the phone calls, Judge, again, I'm not saying he admits or denies that, but he knows he's not to have any contact, third-party contact with the complainant, and that will continue. And so, Judge, I'm asking if my client could have a second chance on this tether. Again, Judge, he could have been like everyone else and just not come back or got caught.
We would have got him. I mean,
and you stole the words out of my mouth, Judge. I said, or he could be standing here today in a green jumpsuit, and he's not. He's here today, Judge, fully accountable for his actions. It won't happen again, Judge. I guarantee it. We plan to address this case. I'm just asking for a second chance.
Counsel, go ahead, anything?
I just would kind of reiterate the facts of this case in which he pointed an AR-15 style rifle at the victim, saying to her, "I'm going to kill you. I'll put a bullet in your head." And on the phone call, he addresses that he knows he's not supposed to be talking with her because when the other person says, "Kia, who is the victim?" he goes, "Don't mention her. She's my case."
And here comes the turning point of the entire hearing. Judge Simpson is no longer focusing on excuses, emotions, or fear. He's pulling the courtroom back to the original allegations. That's critical because judges often reset hearings this way when they feel the conversation is drifting too far into sympathy territory. The defense spent several minutes arguing panic, anxiety, youth, and accountability. But the judge now reminds everyone what the underlying accusation actually is: allegedly pointing an AR-15 style rifle at the victim while making death threats. Once that fact returns to center stage, the entire atmosphere changes immediately. This is why bond violations become so dangerous in violent cases. If a defendant is already accused of threatening behavior and then allegedly violates release conditions afterward, judges frequently interpret that as confirmation that restrictions are not working. That destroys trust. And courtroom discretion depends heavily on trust. What also stands out is the judge's language about games. That's emotional courtroom language, but it carries legal weight. He's signaling that the court believes these actions were deliberate attempts to bypass orders, not misunderstandings. Once a judge reaches that conclusion, bond revocation becomes extremely likely. And let me ask you this: if someone cuts off a tether but still voluntarily returns to court, should that count as accountability? Or does the tether violation alone outweigh everything else? That's the exact debate unfolding here in real time.
So I have great concerns that he will still be violent.
Without playing the game. I don't play games. We don't play games here. You don't get to be put on a tether. Well, first of all, be told that you should not be contacting the victim and then finding and manipulating ways to do so. Don't do it here. Doesn't happen. Won't happen. And then when you get the grace, given the nature of the charges, to get let out, then you're running around and you decide that what the court ordered in terms of a tether, you decide you want to cut it off yourself. We don't do that either. Defendant's bond is revoked, defendant's remanded. I'll see him on the 13th, and counsel, you can give me your argument as to what I should do with his bond at that point. But right now, he's remanded.
Thank you, Judge.
Thank you. Lonnie for the people.
Morning, Your Honor. May it please this honorable court, David Burgess on behalf of Bryant Murphy, who's appearing standing on my right.
Your name? Brian Murphy. Thank you.
Your Honor, we did receive discovery in this matter. We are requesting a preliminary exam in this matter.
All right. People have their witnesses available the 11th.
We will try, Your Honor. I have not had recent contact with my police officers, as it appears that the person's been on bench warrant for a couple months, but we'll try for that date.
Preliminary examination in person, March 11th, 2025, 9 a.m. That's before Judge Washington.
Your Honor, may I address the issue of bond briefly?
Sure.
Thank you, Your Honor.
What's fascinating about this next hearing is how similar patterns keep repeating across different defendants. Once again, the court is dealing with somebody who failed to appear, violated supervision expectations, and now wants another opportunity at release. But unlike the previous case, this one quickly becomes much more damaging because the defendant's criminal history enters the record. Defense counsel tries to soften the situation immediately by admitting the failure to appear and framing it as fear of testing positive at community corrections. Strategically, lawyers often admit smaller violations up front because credibility matters. If the court feels counsel is being transparent, judges are sometimes more willing to listen. But then the prosecution and court records start listing prior offenses: narcotics history, fleeing incidents, armed robbery allegations, prior tether issues, and additional bench warrants. That changes everything. Bond arguments are cumulative. Judges don't evaluate one isolated mistake. They evaluate the entire compliance history surrounding the defendant. And you can almost hear Judge Simpson mentally calculating risk versus reliability in real time. Courts ask themselves one core question during bond review: if released again, will this person follow orders? Once repeated non-compliance appears in the record, convincing a judge becomes incredibly difficult. This is exactly why courtroom hearings can turn so quickly. A few additional facts can completely collapse a defense narrative in seconds.
Your Honor, my client did fail to appear. He was going to go to community corrections, and he knew he was going to test positive. He got scared. No excuse, Your Honor, but He did in the interim, Judge. He did reach out to me. I actually emailed the court to try to do a warrant recall. So he did make efforts he did retain counsel in this matter, but he did make efforts to come back to court to deal with this matter recently, Judge. I did not obviously get that. He was picked up in the interim before I received a response on the email, which was denied. But Your Honor, it's non-assaultive crime. There's no victim here. I'm asking the court. He has been in custody since last Sunday night, Judge. And I know he will appear for all future court dates, Judge.
Really?
Your Honor, may I respond?
You really know he's gonna?
No, I don't think you need to probably, but it's okay. Yeah.
No, that's fine. Go ahead, Mr.
He will,
I'll let
but-
you finish and then I'll
All right.
hear.
Your Honor, and again, he was originally on a PR bond. I'm asking the court to at least consider a 10% bond. He's currently on remand, Your Honor.
And Your Honor, it does appear to me that at the time this came up, the defendant had a tether on and he had a violation with that tether because his battery had gotten too low. The police made contact with him. He had bench warrants for failing to appear and a bench warrant for failing to appear on an assault battery. He had a bag of drugs on his person. It was just under a gram of cocaine, 0.88 grams of cocaine. He has a significant history for delivering or manufacturing narcotics. 2023, reckless. Looks like it was a fleeing third degree that was dismissed for fleeing. 2015, delivery, manufacturing narcotics. 2013, delivery, manufacturing narcotics, 5 counts. 2013, delivery, manufacture narcotics, 2 counts. 2014, delivery, manufacturing narcotics. 2004, fleeing third. 2004, armed robbery, and assault with intent to rob while unarmed.
Yes, Mr. Squirty.
No, Your Honor.
Motion for bound reduction is denied. Bond will continue. Thank you.
What a revealing set of hearings from Judge Simpson's courtroom. Across multiple defendants, one theme kept surfacing over and over again. The court is willing to listen, but it absolutely refuses to tolerate violations of trust. Whether it was competency concerns, tether violations, indirect victim contact, failures to appear, or repeated supervision problems, Judge Simpson consistently focused on accountability and compliance above everything else. In the Benjamin matter, the court acknowledged possible competency and mental health treatment needs, but still refused to loosen restrictions without a structured plan in place. In the Maris-Hankey case, the defense made an emotional second-chance argument centered around fear and panic, yet the alleged victim contact and tether violation ultimately destroyed the court's confidence. And in the final hearing, prior criminal history and repeated noncompliance made bond reduction almost impossible to justify. One thing Judge Simpson made crystal clear throughout these proceedings is that courtroom leniency is conditional. The moment a defendant appears to manipulate supervision, ignore bond terms, or undermine court orders, patience disappears quickly. These hearings also show how emotional explanations and legal realities often collide head-on inside criminal courtrooms. Fear, confusion, anxiety, and regret may explain behavior, but judges still have to weigh public safety, reliability, and enforcement of court authority. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.